Ladies and gentlemen, good morning. My name is Nico Keijser. I've brought with me Ellen Heersen to be backup in order if I do not know any answer to your questions. And then of course we have other members of the working group in the audience to maybe also assist if necessary. Working Group 2 of the EAGLE project has worked on the subject expert proceeding and the experts report. We are very pleased to be part of this plenary conference in which we can present the result of our work. Our working group consisted of 9 people, 5 judges, 2 experts, 1 lawyer and 1 academic. We came from countries like Bulgaria, France, Italy, Belgium, United Kingdom and the Netherlands. Again, at this point, I would like to thank all members of the working group for their efforts to have been available during the meetings over the past year, but of course also for the time spent on the discussion and on the preparations for all the meetings we have had. We have conducted 4 meetings. One was in July last year in Brussels. Then we have met in Paris twice and in Milan, Italy. I would say close by, but it's further away than I think it is, in Italy. We have presented our final report to the data study group March 30 last. The meetings were used to decide on the subject matter, the gathering of information, the preparation, and investigation was done in between these meetings. For this, of course, email and internet were very helpful. Are you there? We want to give you some insight in the highlights of our work of almost 1 year. You will understand it's impossible to share everything with you. Okay. I don't know if this is readable. Our work started with the themes that were acknowledged in the WG2 Expertise project, a previous project of the European Expertise and Expert Institute in 2011 and 2012. In that project, the final report, 12 recommendations were made in the 3 themes shown, being judges' control over the work of the expert, requirements for a fair trial, and the report. Our goal for this project was in general to add value to the WG2 Expertise project, whereas the present EAGLE project is a logical follow-up of the work of 2011 and 2012. We have decided to start with a thorough analysis of the recommendations, both in French and English. And we concluded that in order to be more clear and actually unambiguous, the wording needed some changes. Thus, we transformed the recommendations into statements to which a binary response was possible: agree or do not agree. And the result we presented via a questionnaire in French and English on the internet, and we invited relevant people to respond. The questionnaire, which was also presented in both languages, resulted in 369 respondents from 15 countries. If you look at the numbers, one may conclude that the topic is very hot in Belgium. However, the results of the questionnaire and the remarks that were given with "I agree" or "do not agree" did not give us reason to correct for this high percentage from Belgium, as well as from maybe Italy. In general, we have found that the opinions and the remarks that were given are similar, as we can see in the next figures. As you see by these percentages, most respondents agreed with the statements that were presented. That led us to the question to look into why respondents did not agree. Are there remarks in the case of "I do not agree" that may have led us to reconsider the wording of the proposed statement? And then also, of course, the remarks with "I agree" were investigated to enhance our understanding of how the statement may be falsified. Sometimes a remark added a detail that may also have led to a change of wording in English or French. In general, the findings were as follows. The exceptions given with "I agree" were consistent with remarks given with "I disagree" answers, but of course with a reverse formulation. We also found that there were in general no differences between the nature of the remarks originating from different countries. This leads us to the conclusion that across Europe, even though different systems are in use, the general thinking about proceedings and expert reports are very much alike. Experts seem to be generally dealing with matters in many cases in the same way, taking small differences in applicable law and local rules into the consideration themselves. Judges and lawyers in general appear to take the same view on most issues, but naturally with a more legal perspective than the expert's view. But of course, I would say, we did find arguments to modify some of the original Your Expertise statements. After realizing that changes did not equally affect different legal systems, or by accommodating some of the exceptions that were mentioned by the respondents, the generality of the proposition was lost and eroded its application as being a best practice statement. And then we went back. For each statement, we aimed to retain the main subject and goal in defining it and choosing its wordings. I now come to the part where I would like to address some of the changes we made to the statements by discussing the way we have worked. And I will do this by looking at some changes per theme that we've shown before. Within the theme Judges' Control over the Work of the Expert, the original statement, we have added or changed 3 parts of this statement. If you look at the original, the judge, on his or her own initiative, having heard the parties or at the party's request, should be able to replace the expert, was after consultation and debate within the workgroup changed into, you can read it with me, the judge on his or her own initiative or at the party's or the expert's motivated request, having heard the parties and having heard the expert if necessary, should be able to replace the expert, giving reasons for doing so. And the reasoning behind these changes was as follows. The expert must also be able to request his own replacement, and this was not in the statement from Your Expertise before. For reasons of transparency, the expert must of course motivate his question to be removed. In doing so, parties must be heard, must always be heard, and the expert should only be heard as necessary, not in the case of his own request. And in all cases where an expert is replaced for whatever reason, the judge must give reasons of replacements for reasons of transparency. Working our way through the first themes, this results in these 7 statements that Working Group 2 suggests to be part of a European guide. I am aware that this is a lot of text for such a small slide, but the text will be more readable in the report, and if I'm not correct, you also have the presentation in front of you. We have specifically chosen, although my presentation is in English, and our debate was also in English, we have specifically chosen to choose the wording both in English and in French. As we have found in the Your Expertise project, there were differences between the two languages that were unexplainable. In the theme, Requirements for a Fair Trial, we have changed the original statement. The evidence submitted for expert analysis and the grounds upon which conclusions will be drawn are disclosed to each party. We have changed, and again, please read with me. The evidence submitted for expert analysis and the grounds upon which conclusions are drawn will be disclosed to all parties unless the judge, having heard the parties, rules otherwise, or the parties agree that there are compelling grounds for non-disclosure. And for this I give you the following reasoning. The first linguistic change that we've changed are drawn. A judge might rule by a motivated request of one party that not all evidence is disclosed, but is investigated by the independent expert, the independent trusted expert. For instance, we look at intellectual property case or copyright infringement cases where the evidence cannot be shown to the other party. Also, during the expert's investigation, parties can agree that investigation by an independent trusted expert is sufficient and showing of the evidence is not necessary. Within the theme Requirements for a Fair Trial, there was a statement that gave so much debate that we proposed to split this up and divide this over two themes. The original statement was, there should be a preliminary report disclosed to the parties in all cases. And after our consultation over the internet and the debate within the working group, we split this up. We have put one part in the vision judge's control over the work of the expert, where we say there should be a preliminary report disclosed to the parties, and then added unless the judge or the law dictates otherwise. The missing component was to the section Requirements for a Fair Trial. If no preliminary report is presented, which is possible in some countries or some cases, parties shall have the opportunity to give their opinion before the expert, before a final ruling by the judge. By splitting up the original statement as presented above, we meet both requirements of being able to discuss your report before the judge and also discuss a preliminary report with the expert. That leads to section 2 with the following 4 statements that we suggest to be part of a European guide. For theme 3, the report, in this theme, many reactions stated that no model can fit all types of reports or opinions, and we agree to that fully. The variety of technical issues and technical areas that reports are prepared on is simply too wide to present it into one model. However, we do feel that it's possible to present some subjects that are mandatory and subjects that may be addressed and should be there in every report. We also suggest that these subjects should always be in the same order, which will make it easier for judges to read and interpret the reports and opinions more easily. Also, it is very important to show in any final report what was changed if compared to any preliminary version. Again, I am aware that this slide may be difficult to read, but here we present the proposed statements for the theme on the report. Finally, we make a maybe little confusing step on the themes. For the Eagle project, as compared to the Your Expertise project of 2012, 3 new themes were presented to work on. And we were asked to work with the themes A, defining the judge's role, B, determining the structure of the expert's report, and theme C, establishing a common European procedure for civil experts. These themes should find a place in the European Guide for Legal Expertise, which is hopefully the result of this project. We propose to place our statements into these Eagle themes as shown on this slide, where we must establish that all of our statements hold a place in theme C, establishing a common European procedure for civil expert, as that being the most important theme, overall theme in this project.